appeal in the matter of GHL.
Yes, Ms. Gallagher, good morning.
Thank you. My Lords, I appear on behalf of the appellant, a child now aged 16, who, as you'll be aware, was aged 14 at the key time in question, and who's referred to as AG for the purposes of these proceedings. And to start with some introductions and then deal with some housekeeping, I'm aware there's some housekeeping issues we need to deal with before we get into the substance. I act for AG along with Ms. Tatiana Eatwell and Mr. Chris Barnes, instructed by Bat Murphy. AG, as you'll know, my Lords, was not the applicant in the court below. That was the London Borough of Barnet, now the first respondent to this appeal. They're represented by Ms. Hannah Markham, King's Counsel, Ms. Kate Tompkins, and Mr. Peter Webster. They may assist you to know at this stage that I understand their oral submissions will be split between Ms. Markham, King's Counsel, and Mr. Webster. And the Secretary of State for Foreign, Commonwealth and Development Affairs, the second respondent, is represented by Sir James Eadie, King's Counsel, Professor Vaughan Lowe, King's Counsel, Joanne Clement, King's Counsel, Jason Pobjoy and Belinda McRae. May I start by dealing with some housekeeping, and may I start on behalf of the bar as a whole by apologising to you for the disruption and to your clerks for their patience and assistance overnight with the flurry of paperwork.
What disruption?
And its electronic
flurry
equivalent.
of paper, yes.
And so, my Lords, you should have a core appeal bundle and a supplementary appeal bundle. I'm conscious, my Lord, the Master of the Rolls, you of course will be working electronically.
Yeah,
only.
we've got that. We've now got 3 authorities bundles, a supplemental and second supplemental, both of which have been replaced. I think we've got everything.
I'm grateful. May I just indicate that there's been agreement amongst the bar because of the overnight production of authorities. There's an overlap of a number of tabs. So the second supplemental bundle will now refer to as tab 66, 67 and 68, with apologies for the disruption.
Okay, don't worry, just let's get to the substance.
Thank
and
you.
What's the timing? That's the only thing I'd like to know.
Yes, we're listed for a day and a half, my Lords, and we've liaised with the council team for Barnet, and we anticipate that between our submissions for the appellant and Barnet will be completed before the end of today. You're likely to hear from the Secretary of State, I anticipate, before the end of today, with those submissions continuing into tomorrow morning and then a short reply.
Before the end of today. I think you should be aiming for something like 3 o'clock because you're going to want to reply.
Yes.
And the reply might be the most important part of the case. So can you aim for 3?
Me to aim for 3, or
no,
for us and
both
Barnet?
of you.
Yes, I think we can make that work.
Yeah.
We've liaised trying to make that feasible. We're conscious also that many of the materials are in fact summarised in the judgment below, so I won't turn up authorities unless completely essential.
You can assume quite a lot of reading has been done by the court.
I'm grateful.
Even thinking, Scallagher.
Yes, of course.
And it's dangerous for the court to do that.
My Lords, I intend to outline the route of my submissions and our headline core propositions about what this case is not about in a moment. But before I do so, my Lords, may I draw to your attention the fact that AG is present in court today, accompanied by her social worker. This case, of course, concerns vitally important matters of principle, and indeed, as recognised in both orders made by my Lord Justice Moylan at Core Bundle 73 and Core Bundle 78, the interrelationship between the Children Act 1989 and the concept of diplomatic immunity is an issue which merits consideration by the Court of Appeal, it never having been considered by this court before. But at the heart of this case is a child, AG, who's present in court today, and her siblings. And I wanted to start with reference to that before I turn to my core.
Can we just be clear about the anonymity, so we
Yes.
don't make any mistakes?
Yes, that's right.
The country concerned has not been identified.
That's right. The country concerned has not been identified. So the country concerned I'm going to refer to as the sending state, or the state in question. I won't refer to that. And my client wishes to be referred to as AG. There is, of course, an anonymity order in place. A is a child who's a victim of physical and psychological abuse at the hands of her parents, who happen to be diplomats. As you'll be aware, AG
Sorry,
is one
can I
of...
just, you say there's an anonymity order in place
Yes,
made by the court below,
yes, that's correct.
right? And the members of the press, either present or online, have been notified of or aware of that, the terms of that order?
If you give me a moment. They were served previously. I'm not
Right.
aware of any new steps having been taken. It's obviously clear from the judgment.
Anyway, there is an anonymity order.
There is indeed.
And so anybody who is considering reporting the details of this case should make themselves aware of that anonymity order, and they can get in contact with your solicitors.
Yes, they
who
may
will
indeed.
provide them with a copy of the order to ensure that they don't, or that they do rather, comply with the terms of that order.
I'm very grateful. Thank you. Yes, my solicitors, Black Murphy, would be happy to provide a copy of that order to anyone who requires it. And
You've already named the authority.
yes, that's right.
The
And the authority is named below.
Okay, fine.
So we're sticking to the same principles from below. So the authority is named, the country is not named, reference is made to the number of siblings. But we're very mindful of the issue of jigsaw identification. We anticipate members of the press who are reporting this case will be aware of the issue of jigsaw identification. And that's why we have to rather laboriously refer to the sending state, or the state in question. We're not referring to the state in question. My Lords, I just wanted to start by focusing on AG, who's at the heart of this case. And I was just making some preliminary remarks about that. AG is, of course, a child who's a victim of physical and psychological abuse at the hands of her parents, who happen to be diplomats. She's one of 6 children of a couple, a diplomat and his wife from a foreign state, and that family unit was previously based in Barnet. This case is also about a child who's now separated from her 2 younger siblings as they've returned with their parents, the diplomatic couple, to the sending state, whilst AG and her 3 older siblings remain in the UK. And may I ask you to turn to the supplementary appeal bundle, which contains a statement from AG. And it's tab 16 of the supplementary bundle, page 95. I just wanted to turn at the outset to paragraph 2. Where AG says, at the time she made this statement, she was 15. I'm currently in the care of the local authority. My solicitor asked me if I wanted to continue to be involved in the other part of the court case about the difficulties about being safe if things go wrong in your family and you're the daughter of a diplomat. I really wanted to be involved with this, as it was just awful for me at the time, being very scared and feeling powerless, and I wanted the court to know what it was like for me. And similarly, at the end of that statement, at paragraph 37, page 99, AG says, I'm very grateful to the authorities, including Barnet, for being able to stay here in the UK. I'm sorry I couldn't help my little siblings. I was old enough to run away and had been given a number of a solicitor to help me and to make sure I was safe. What I went through was terrible and scary, but not being able to speak about it to social services because of fear was terrible too. I wanted myself and my siblings to be safe and would not want any other young person to be in that situation, but to be able to get help. And the reason I say that at the outset is that we'll be discussing over the course of today and tomorrow morning matters of high principle and complex legal concepts. But the reason AG is here is precisely because she is indicative of a wider group of children of diplomats who simply do not have the same protections which other children in this jurisdiction are afforded through the Children Act 1989, particularly Part 5, at issue in this case. And there's a reference in the Secretary of State's skeleton argument to this claim being, and I quote, entirely academic. That's the phrase used of paragraph 69(1) of the skeleton core bundle, page 153. And there are references in both the Secretary of State's skeleton argument and the judgment of the divisional court to the effect that the system essentially worked here, with the steps which were taken having achieved directly and indirectly protection for the 4 children still in the UK. That's a quote from the judgment, paragraph 95, core bundle 60.
And you say it didn't work for the other siblings, and you say it's a very serious situation. And let me assure you, Miss Gallagher, and let me assure everybody listening, the court takes extremely seriously the facts of this case and regards them with the greatest possible gravity. Having said that, however, we do need to focus on the legal issues which are the subject of this appeal, which, as you say, are complex and require rehearsal and argument. And so whilst I quite understand why you want to make it clear to us that there are real people involved in this case and that the circumstances that gave rise to the case are of the greatest gravity, we do need to get on with the legal arguments.
Of course, I entirely agree and understand that, my lord. The simple point which we make is that neither the assertion that the claim is entirely academic, nor the suggestion that this case in some way involved the system of child protection working for children of diplomats is sustainable here.
No. And whether it's academic or not, if you're entitled to a declaration of incompatibility, then you must have one.
We're very grateful, and we're conscious that that's a point to which Sir James is likely to return, given paragraph 69 of his skeleton, and we'll deal with the points which he makes in reply. Our headline point is the case is relied upon Nasseri, Rusbridger, and so on in paragraph 69 simply are not akin to the circumstances of this case. This is a rare situation in which this issue has come before the court. And that's the first point that I wanted to turn to about what this case is not about. On reading the Secretary of State's skeleton argument, you may have the impression that this is essentially an area of settled law, with you being asked to depart from well-established principles before the Strasbourg court and the domestic courts. And that is simply not correct. And both the appellant and the local authority in our submissions today intend to make clear why, when this case came before the divisional court, it was essentially a blank slate case, a topic which had not yet been decided. Now, the closest cases which you have before you are 2 cases at first instance, which were referred to in the judgment below.
That's the decision of the president, the former president,
yes,
and of Mrs. Justice Gwyneth Knowles.
Yes, that's precisely right. Now, those, of course, are on a slightly different point because they relate to lower-level diplomatic staff for whom there's a carved-out exception if they're not acting within the terms of their role. But it was considered in that context in those 2 cases. And then you also have, at the other end of the telescope, 2 Supreme Court cases considering a situation which has some analogy to the current situation, and that's the Reese case and Basfor and Wong, which of course was decided after the skeletons in this case were provided to you. That's from July 2022. Now, they're both cases about trafficking and diplomats. And as you'll have seen, very heavy reliance was placed by the divisional court below, and indeed by the Secretary of State in their skeleton argument, on the analysis of Lord Sumption in the Reese case. And just at the outset, we want to make clear to you that the Reese case and Basfor and Wong.
Where do we find them?
So the Reese case, my lord, is in tab 10. So for those of you working with hard copies, it's volume 2. It starts at page 532 of the authorities. And Basfor and Wong, decided in July of this year, is at tab 16 of the same bundle, commencing at page 774. And may I just give you the headline point now while we're dealing with these cases? So in the Reese case, Al-Makli and Reese, the claimant was employed as a domestic worker by a diplomat and his wife at the official diplomatic residence of a country's mission in London, and she brought claims against her employers for race discrimination, failure to pay the minimum wage, and she alleged mistreatment, including trafficking. And The employers claimed diplomatic immunity in that case, pursuant to Articles 31 and 37 of the Vienna Convention. And an employment judge concluded service had been validly effected on the solicitors, and on the assumed facts, the employment of the claimant should be regarded as being within the exception to immunity in Article 31, 1C of the Convention for claims relating to commercial activity outside the diplomat's official functions. And the EAT then allowed an appeal by the employers, holding that they could rely on immunity, although they had been validly served. And position then is that the diplomat's posting came to an end. So by the time the case came before the Supreme Court, the posting had ceased. Now, importantly, there was a majority and a minority in that judgment. The majority was Baroness Hale, Lord Wilson and Lord Clark.
Lord Wilson's the judgment, isn't it?
That's right. And Lord Sumption and Lord Neuberger are in the minority, excuse me. And what we see in the judgment of the majority is that although they say the proper construction of Article 31 didn't arise because as a matter of fact the employers were no longer entitled to immunity because of the posting having come to an end, a number of factors were set out. This is particularly in paragraphs 57, 59 to 62, 68 and 69. I won't turn them up, but I want to just give you the headline points and then I'm going to turn...
This is from Lord Wilson's judgment, is it?
Yes, that's right.
Could you give me those numbers again? I'm sorry.
It's 57, 59 to 62, 68 and 69. And the approach which was taken by the majority, my lord, in those paragraphs was to identify a number of factors. And it starts, paragraph 59, reference to the first factor. Based on the evidence before the court, the UK confronts a significant problem in relation to the exploitation of migrant domestic workers by foreign diplomats. And there was evidence before the court from an NGO, a UK charity devoted to advising and supporting migrant domestic workers on that issue. So, first point that the majority turned to was the fact that the exploitation of migrant domestic workers by foreign diplomats is a significant problem. Second factor that they highlighted, at paragraph 60, my lord, is what's described as the universality of the international community's determination to combat human trafficking. So universal condemnation in the international community and a determination to combat it. And then the third factor which they highlight is that the employer of a trafficked migrant is an integral part of the trafficking chain. And we see that in paragraph 61. And that's the context in which they said, although the issue about the proper construction of Article 31 didn't arise on the facts, given those factors, it seemed to the majority of the Supreme Court 5 years ago, in this case, that the International Law Commission should be invited to consider the international acceptability of an amendment of Article 31, which would put beyond doubt the exclusion of immunity in a case such as the present. Now that's the context in which you then need to see Lord Sumption's analysis relied upon so heavily by the Divisional Court, because Lord Sumption, in the minority judgment, and Lord Neuberger, took the view that the exemption would not in any event have applied. The employment of a domestic servant to provide purely personal services is not, in their view, a professional or commercial activity exercised by the diplomatic agent, not therefore within the exception to immunity. And the analysis about why the exceptions are so limited in that minority judgment go towards that end result.
It's overturn a minority judgment.
Yes,
is that
precisely.
what you're saying?
That's precisely it. And, my lord, what we now see in Basfor and Wong from July 2022, starting at page 774, is a pithy summary of precisely that point at paragraph 3. Now, in this case, Basfar and Wong, very similar circumstances to Reese. The claimant, again, employed by a diplomat in Saudi Arabia, brought to the United Kingdom to work for him as a domestic servant in his diplomatic household. Again, at issue is conditions of employment and being subject to trafficking in the United Kingdom and exploitation. And in these circumstances, when looking at whether the Article 31 exemption, professional or commercial activity by the diplomatic agent outside his official functions, applied, we didn't have the same situation that you had in the case 5 years ago, because the diplomat's posting had not ended. So you'll see the majority judgment, Lord Briggs and Lord Leggett, with whom Lord Stevens agreed, starting at page 778. They describe how the Supreme Court has considered this question once before in the Reese case. They say at the bottom of page 778 in paragraph 3, having reached the conclusion on the facts, there was no need to decide whether, if he'd still been in post, the diplomat would have had immunity. A minority of the Supreme Court expressed a clear view that he would, but a majority of the court considered this to be very much in doubt. So that's the context in which, when you see the repeated references to Lord Sumption's analysis, it must be seen, must be placed first in its proper context when you look at the case from 2017 of Reese, minority judgment, obiter, and fundamentally at odds with the analysis of the majority in Lord Wilson's speech. And secondly, it's got to be seen in the context of the Supreme Court having revisited the issue in Basfar and Wong, summarising the Reese approach in paragraph 3, and ultimately, in Basfar and Wong, the decision of the Supreme Court was to allow the appeal, to conclude that the exploiting of a domestic worker by compelling her to work in conditions of modern slavery does fall within the exemption. And so we have these two recent cases, but of course we don't have an equivalent of the Article 31 exemption here. The reason it's important is that the analysis relied upon so heavily by the Secretary of State and indeed by the Divisional Court, if I can call it the chicken licken analysis, about what would happen if this exemption were allowed. The Supreme Court has in fact taken quite a different view. And
Well, is there any, you've taken us to some passages in Basfar and Wong, is there anything in any of the judgments in which Lord Sumption's analysis is critiqued? You told us it's referred to.
Of course.
Is it critiqued? Or is it did their lordships focus on the question of whether, on the fact of this case, the diplomat was engaged in a commercial activity outside his or her official function? Seems to be.
Could you just give me a moment? I'm conscious. I'm just conscious that Miss Markham, as I understand it, is also going to turn to this, so I just don't want to tread on toes too much. But my lord, while you've got it open, you will see analysis of Lord Sumption's analysis, paragraph 60 in particular, and 61, page 792. And you'll also see paragraph 68 onwards, analysis by Lord Briggs and Lord Leggett of Lord Wilson's approach about the relevance of developments in international law about modern slavery. And when we go back to those principles that were set out by the majority in the Reese case, we see that reflected in Basfar and Wong. So we see in Basfar and Wong again a recognition that here, when considering the boundaries of diplomatic immunity, those key factors identified by the majority 5 years earlier, the exploitation of migrant domestic workers by foreign diplomats being a significant problem, and universal condemnation in the international community of human trafficking and a determination to combat it. We see that running through the majority decision again in Basfar.
Well, I mean, I don't want to take up time on this, but at the moment, my feeling about this case is that it was focused very much on the commercial activity exception,
Yes, that's right.
rather than any broader principle enunciated by Lord Sumption. But maybe you're going to come back to that.
Yes, and this is why, at the outset, my lord, I wanted to make clear that this is not a case in which there's settled law. We think that the closest analogous situations, but they're obviously not complete analogies because the circumstances are different, are those two first instance judgments about lower level diplomats and these two cases from the Supreme Court. But the principles identified by the Supreme Court about, number one, the nature of the problem, and number two, international condemnation of this kind of activity, trafficking of an individual for domestic servitude, and a willingness and imperative to combat it, are analogous to this situation. Because what we have in our scenario is a situation in which the children of diplomats, precise number not known, it's a sizable proportion of the 23,000 individuals within the jurisdiction currently, who are estimated by Mr. Justice Mostyn to avail of diplomatic immunity, and that includes a number of children. They are simply excluded from the child protection system in place under the Children Act 1989. Now, I appreciate and will come to that there are some steps which can be taken in certain circumstances. But the scenario that we have here is that children of diplomats who are in England and Wales, unlike all other children in England and Wales, don't benefit from that detailed scheme of child protection, support and care. Now, in this particular instance, we're dealing with physical and psychological abuse. You have the evidence before you about how grave that was for AG and for AG's siblings. And the findings of the court below, that what occurred went well beyond the point of cruelty, sometimes required medical treatment for their children. And of course, you know that in January 2020, the court had formed the view that AG and three of her siblings have made allegations which substantiated concerns that they'd suffered and were at risk of continuing to suffer significant physical and emotional harm from the routine actions of both parents, excessively harsh and very severe in discipline and punishment, well beyond the point of cruelty. But of course, that group that we've spoken about, the proportion of the 23,000 individuals with diplomatic immunity presently in the jurisdiction, will also include children who may be at risk of other forms of abuse.
What's that figure?
It's 23,000 is the figure. And, my lord, if you want the reference for that, it's paragraph 30 of the judgment, core bundle, page 38. I won't turn it up. A key point was the divisional court cited Mr. Justice Mostyn's reasoning that this is not an insignificant number. Approximately 23,000 people in the UK who benefit from diplomatic immunity. Of necessity, that number would include many children. So precise number not known, but we're dealing with thousands.
23,000 people, a proportion of which will be children.
Yes, that's right. Now, this case concerns physical abuse. But the result of the approach taken by the divisional court, and indeed by the Secretary of State, would apply to a range of other circumstances, including sexual abuse, FGM, and other forms of abuse. Now, there are a number of cases relied upon by the Secretary of State, and I'm going to turn to some of those in a moment, but there's a headline point to make right at the outset, and that is the case law that the Secretary of State relies on to make the case that there is no incompatibility between diplomatic immunity and the state's positive obligations under Articles 1 and 3 of the European Convention fall into one of two categories. they are either, number one, state immunity cases and concerning Article 6(1) of the ECHR, or second, they're diplomatic immunity cases concerning Article 6(1). And those cases are entirely distinguishable from the issues in AG's case on three fundamental grounds. The first is that cases concerning the right of access to the court under Article 6 and the application of the principle that immunity, whether state or diplomatic immunity, doesn't qualify the substantive right. Rather, it's a procedural bar to the national court's power to determine that right. That's a central principle. And closely related to that when dealing with diplomatic immunity. Diplomatic immunity is not personal immunity, it's functional immunity. And in essence, what that means is that there remains a right of access to a different court because a claim can be brought in the sending state's court, or if the conduct is not part of the diplomat's functions, after the diplomat's term has expired. So when you're dealing with an ex post facto case concerning access to the court to secure accountability, the scenario is very, very different to what we have here. And the third point is that the cases concerning torture and ill treatment all concern claims that are ex post facto. They do not concern the state's positive obligations under Articles 1 and 3 of the European Convention to take measures to prevent the torture or ill treatment of persons in the state's jurisdiction in circumstances where torture or ill treatment is ongoing and the state has knowledge of it. And that's why we say this was a blank slate case. And it's quite wrong to present it as a scenario in which there's settled law, new being asked to adopt an approach which is at odds with Strasbourg case law, as is repeatedly asserted. It's simply not correct. And there's one other point at the outset that I want to deal with. And that relates to the genuine emergency exception. So sorry, my bundle has given up, just fallen apart. Could you just give me a moment? So in the core bundle, page 250, you have the skeleton argument of the Secretary of State below. It's paragraph 90, and the genuine emergency exception. And you see reference at paragraph 90. We agree with the Secretary of State's analysis on this point, to the United States Diplomatic and Consular Staff in Tehran case, the ICJ judgment of 24th of May 1980, paragraph 86. The observance of the principle of inviolability does not mean that a diplomatic agent caught in the act of committing an assault or other offence may not, on occasion, be briefly arrested by the police of the receiving state in order to prevent the commission of the particular crime. And there's a number of examples of that. You'll see the example, paragraph 92.3 down the page, which is often referred to, of the diplomat drunk in charge of a motor vehicle. And you've seen the reference that we've made to the Bahrain embassy and the individual on the roof. And in essence, to the extent that that principle the genuine emergency exception has been developed so far, it focuses upon clear and present immediate danger where life is at risk. And the examples tend to be...
Where life is at risk.
I'm so sorry, my lord, I didn't hear.
I didn't hear what you said.
Ah,
And I still
You
haven't
said
heard
where life is at risk.
where life is at risk.
Thank you.
I'm so sorry, my lord, I have a slight hearing issue, so if I haven't heard anything, please do repeat it.
Okay.
So to the extent that that genuine emergency exception has been developed so far, it tends to be focused on clear and present danger, life at risk. And you have situations where the risk is manageable through temporary measures being taken. So you have a drunk diplomat, for example, who's in charge of a car and who's on the road, and the car may hit someone. You're able to put him in a cell for a period of time or hold him until he sobers up. You're able to take him away from the car.
So what are you saying? Are you saying that we should extend the genuine emergency exception?
No, I'm not, my lord.
No,
So
because that's not in your...
No, I'm not saying that at all. I'm explaining, if you'll just let me make the point, my lord. The point is this. The scenario that we're dealing with here in relation to child abuse, behind closed doors, and often involving a pattern of conduct over a long period of time, is a risk of a different nature. It's not a risk like a risk from a drunk ambassador in charge of a motor vehicle on the car, in charge of a motor vehicle on the road, where you can take a few hours to get him to sober up, and then the risk is dissipated. It's not a situation like a punch-up outside a pub, where again you can separate the parties and then the risk dissipates. It's an ongoing systemic risk over a long period of time. And as it's currently developed, that genuine emergency exception does not appear to us to apply to even a scenario like a baby P type scenario, where you've got very serious risk in relation to child abuse. And it certainly doesn't apply to a scenario like ours. And that's why, in this case, the local authority in the court below, as supported by my client, took the view that there simply wasn't a way within the existing framework of that exception being said to apply to this scenario. Maybe at some point in the future a different view will be taken at an international level, but on the existing case law at international level, it would be, the exception does not appear to apply to our scenario, the genuine emergency scenario. And we're not in the territory of having an Article 31 exception related to commercial activity, like in the two Supreme Court cases that we've just referred to. And we also don't have an exception such as exists for lower level diplomatic staff, which form the basis for the reasoning in the two first instance cases that I referred to earlier and that we've provided to the court. And there was unanimity in the court below, and there's unanimity before you now, that this is not a situation in which you can read in and carve out an extended exception or a new exception. And that's why it's come to you as a declaration of incompatibility case. It's for that reason. That's why I've made reference to the genuine emergency exception at the outset. Now, the background to this appeal, my lords, is of course set out in some detail in the judgment, and I don't run through it. I do want to highlight a number of factors which are not in dispute before turning to looking at what Article 3 requires and why, in our submission, Mr. Justice Mostyn was quite right in early 2020 when he described there as being a seemingly irreconcilable clash between two international treaties incorporated into our domestic law by statutes, and why we say there should be a declaration of incompatibility in this case.
While you're mentioning the declaration, the declaration sought below is in, I think, paragraph 3, if I got the right paragraph, of your submissions. I got it right? I hope I got it right.
Yes, you do.
And there were two parts of it, to it. One, it was preventing a court from hearing and deciding an application, and the other was preventing a number of authorities. As speaking for myself, as I understand your written submissions, you're no longer pursuing a breach of Article 6.
No,
You're not.
we're not.
So you're only pursuing a breach of Article 3.
Article 1 and 3.
1 and 3.
Yes.
Obviously. Yes. So what does that do to the terms of your declaration?
Yes, we did.
Because it would seem that you would now be seeking a different declaration.
Yes, and the way we've put it in the skeleton is that we suggest, my lord, that the court should agree to make a declaration of incompatibility with appropriate reframing in light of the court's conclusions. Now, that's an approach which has been adopted in a large number of the cases in which a declaration of incompatibility has been granted, and where the declaration is made in very general terms about there being an incompatibility between the relevant article and the primary legislation.
But your primary case is the effect of the DPA incorporating the Vienna Convention into domestic law is that the children of diplomats are excluded from the child protection system under the Children Act.
Yes.
With the consequence that their Article 3 rights, 1 and 3 rights, are breached.
Yes, that's right.
Right? So, which elements of the, if you're no longer pursuing access to court, which elements of the child protection system are you focusing on?
Could you just give me a moment? So, so we, as the appellant, are not pursuing an argument based upon Article 6. We are pursuing an argument based on Article 3.
Yes.
Now, access to the court, because the child protection system does involve, necessarily, access to the court.
Yes.
There is an access to court issue arising under Article 3, but we do not pursue an Article 6 argument.
Right.
That's not something that we're pursuing. Maybe Ms Markham wants to address you on this. Just here. Until they do take the same point. Apologies. So there isn't an argument about Article 6 in this case.
But are you saying that the whole of the child protection system,
Under the Children Act and associated regulations, guidance, etc., is excluded? I don't think that's the Secretary of State's case. The Secretary of State concedes that the actions taken by the local authority were not prevented by the Vienna Convention and the DPA. I think I've got that right.
But my lord, this is why at the outset I did stop when I was asked to by my lord the Master of the Rolls. This is why at the outset we did want to deal with the assertion that somehow the system worked in this case, because here you had a number of factors which have resulted in AG being present in the UK now in a way which many other children in this scenario would not. One of them simply was COVID and time frame. One of them was that she escaped through a back door, as you'll have seen from the statement. She and one sibling escaped through a back door. She happened to have the number of a solicitor. The solicitor happened to answer the phone. There's a series of circumstances which are, if I could put it this way, the opposite to a perfect storm, which resulted in AG being present in the UK.
Fortunate events
Fortunate events.
led
Precisely.
to your client, who of course is an older child,
Yes.
being able to take steps herself.
So she was 14 and was able to leave. Her younger siblings were not. A child in a baby P type scenario would not be able to. A younger child would not be able to leave in those circumstances. So the suggestion, which we get from the Divisional Court's judgment and we get again from the Secretary of State's skeleton, that somehow the fact that 4 of the siblings are in the UK shows that the system works, is nonsensical. And that is not a position which either I, for the appellant, or the local authority support. Here, you've had, despite the absence of an effective system of child protection, you've had AG managing to get into the care of a local authority and to be here and away from the hands of the abusers. But her younger siblings have simply not had that. And that's because of what we say are systemic failures and the absence of protection under the child protection scheme in Part 5 of the Children Act 1989 for uniquely the children in that 23,000 number, the children of diplomats in England and Wales.
But my lord asked you which elements of the child protection system you were focusing on.
Yes.
And you said, well, the child protection system involves access to the court, but that arises under Article 3. And speaking only for myself, I just need to have that explained to me.
Of course. So the submission which we make, my lord, is that an inherent part of Article 3 So, my lord, our submission is, first of all, that insofar as the current situation prevents compulsory measures of child protection being taken in relation to children of diplomats, there's an incompatibility between the Children Act 1989 Part 5.
Sorry, just say that again. Current prevents, phrase used, compulsory.
Insofar as it prevents compulsory measures of child protection being taken in relation to children of diplomats.
Compulsory measures of child protection.
In relation to children of diplomats. Because, of course, certain steps which were taken here at an earlier stage were taken in circumstances where there was initially permission for the children to be spoken to. That's not something which is guaranteed under the current system because there's no element of compulsion. You're reliant upon, firstly, the individual diplomat agreeing to the children being interviewed, or you're reliant upon the sending state agreeing to a waiver.
The child protection scheme under the Children Act includes Part 3, 4 and 5. I
Yes.
notice you're confining so far your references to Part 5. For my part, I'd like to know precisely what are you meaning by the compulsory measures of child protection. I'm thinking Section 31, which is in Part 4, and the emergency protection provisions in Part 5, and the child assessment provisions in Part 5. What? I'd like a list, please, of those parts which you say are incompatible.
You'll have seen that the local authority below gave you a list which did also include Part 3, so it included Section 17, for example, so the assessment in relation to a child in need. We are focused, in our case, on Section 47 of the Children Act 1989 in particular, where you've got a situation as here, where there's suspected serious harm, significant harm to the child. And we haven't, in our skeleton, taken the point about Section 17, the Part 3 child in need provisions. Maybe Miss Markham wishes to address you on that.
Well, at the moment I'm struggling with precisely what you're focusing on, the compulsory measures, but maybe it'll become clearer in due course.
Could you give me a moment? So, my lord, we don't say anything about Section 17 in Part 3. We recognise, of course, Section 17 is part of the process of assessment of a child, and it may be that the local authority does wish to address you on difficulties that arise in relation to Section 17 and assessment. Our focus in particular is Section 47 of the Children Act and any care order to enforce Parts 4 or 5, including emergency protection orders, police protection, Part 4, interim care orders, Part 5, EPOs. And in essence, what these are, in Parts 4 and 5, are of course orders designed to compel engagement. And in this circumstance, we've had some initial voluntary engagement, which you may not have in other circumstances, but the court was powerless to actually take action. And that's why, when the case gets before Mr. Justice Mostyn in January 2020, he is unable to act, and when he considers the matter in March 2020, he's unable to make the interim care order which he otherwise would have made.
See, all the things you're talking about, care order under 31, interim care order under 38, EPO, child assessment orders, are court orders, aren't they? So, why doesn't that engage Article 6?
So, my lord, it could be characterised in that way. It's not how we've put it in the appeal, simply because in our submission, what you're dealing with here, fundamentally, is a breach of Article 3, because you don't have the protective measures which are required to be taken under Article 3 in order to ensure that there is effective protection for Article 3, including effective protection in respect of the actions of private parties. You simply don't exist for this category of child.
Well, you say that, but you say you don't have protective measures under Article 3. But going right back to what my Lord Justice Moylan asked you, he asked you which elements of the child protection system you're focusing on, and you answered, in answer to my Lord Justice Baker, Section 47. And Section 47 is headed Local Authorities' Duty to Investigate. Right? Now, much of Section 47 can be done. It's only the bits that relate to a court order, a child protection order, which is emergency protection order mentioned in subsection 2 and so on, that can't be done. Now, I think the reason my lords were asking you which elements you're focusing on is because we're going to have to ask the question ultimately whether those elements are indeed give rise to incompatibility.
Yes, of course. And if you look back at paragraph 3 of the skeleton, which has the Barnett formulation.
Paragraph 3 is the order that the Barnett sought.
Yes. I presume you're in an
And
unusual position.
that you seek, because you haven't put forward any other.
No, that's right. My lord, we did take the view, having looked through the number of cases in which a declaration of incompatibility was granted, where you're dealing with a slightly more nuanced or complex situation. It's very common for the court to say, in terms in the judgment, we're granting a declaration of incompatibility as a matter of principle, and then for the precise contours to be worked out afterwards. But we have not focused in our submissions on Section 17 of the Children Act, Part 3, or Section 11 of the Children Act 2004. Important though those provisions are, our focus is on the provisions in Parts 4 and 5, so Sections 31, 38, 43, 46 and 47, with 47 being the gateway, because ultimately you have a situation where you have suspected serious harm, and you have a process under the Children Act which then allows for investigation of that suspected harm.
I mean,
and then
my
ultimately
Lord's
comes to the
point
order.
is that the process can be followed. What can't be done is to apply to the court for an order.
Yes, and we've envisaged care orders as a function of Article 3 protection. That's how we put the case. Now, we entirely see, of course, to my Lord's question, that it could alternatively be characterised as the orders being a feature of Article 6, but that's not how we put the case. Our submission is that here, the orders which the UK is prevented from making in a circumstance such as these
I mean, you said a minute ago that you were going to start by telling us what were the duties under Article 3. And that did strike me as promising, because it seems to me you do have to identify what you say are the duties under Article 3 which are inconsistent with the provisions
Yes,
of the Diplomatic Privileges Act.
yes. No, that's quite right, my lord. And to this point, the issue for us, I hope I've answered the question sufficiently clearly for my lords. Our characterisation of the orders here, which are not available uniquely to this class of children, is that those orders are a function of Article 3 protection. And indeed, it's not solely the court orders. It's also, as is made clear from the facts, may in fact be sensible just to turn up the judgment to deal with this. It's also restrictions upon what the local authority and the Metropolitan Police could do in these circumstances.
Well, we're concerned with Article 31, are we? Immunity, is that the phrase? Immunity from its civil and administrative jurisdiction.
Yes.
So that's why that is the phrase in the Vienna Convention that we're focusing on.
Yes, that's right. And this is its civil jurisdiction. But the steps which could be taken by the local authority were reliant in large part upon voluntary engagement, which was provided at some points and not others. And what happened here is that the range of steps which the local authority and the Metropolitan Police could even take to investigate the concerns, let alone protect the children, were restricted given that immunity. And we see that clearly from the judgment. It's not in dispute at paragraph 3, where the summary is given by the Divisional Court about the restrictions on what Mr. Justice Mostyn could do. Mr. Justice Mostyn was then unable to make the interim care order that was sought, which he otherwise would have made, solely because of the status of the children as children of diplomats. And that's the context in which he expressed the very provisional view about a concern that there may be an incompatibility issue between Articles 31 and 37 of the VCDR and Articles 1 and 3 of the ECHR. Now, could I turn to the question I've been asked by my Lord the Master of the Rolls regarding Article 3 of the Convention? Now, Article 3 of the Convention is addressed in the judgment, paragraphs 57 to 62, and you'll have seen from the skeleton argument that we've put forward and also the skeleton argument of the local authority that we both criticise the Divisional Court's analysis of the actual requirements of Article 3. You get the detail in the local authority's skeleton from paragraph 9 onwards, and in our skeleton from paragraph 16 onwards. And that then infects the later analysis by the Divisional Court, when the Court wrongly contrasts at paragraph 98 of the judgment what they describe as the global reach of the VCDR against what they belittle, referring to the purely regional concern of the ECHR.
Well, I mean, you can look at it as belittling, but I mean, it really could just be said to be a question of fact. The ECHR applies to Europe, and the Vienna Convention applies more broadly. I don't completely see why that enables you to get a screwdriver into the judgment. I think, you do need to tell us what are the duties under Article 3 that you say pertained that the judgment did not deal with.
Yes, of course. So, my Lord, the first point is that underpinning Article 3 of the European Convention is prohibition of torture, inhuman and degrading treatment, which is one of the few accepted Jus Cogens norms of customary international law. And you see the references that we've given you to that in paragraph 18 of our skeleton, including Pinochet number 3, the Jones case, and the Belgium and Senegal case.
Yes.
And we've given you the quote. I won't turn it up just because of time. We've given you the quote. It's at page 2089 of the authorities bundle from Belgium and Senegal about the fundamental nature of that prohibition as a matter of international law. And what you then have in Article 3 is a regional encapsulation in the ECHR of that aspect of customary international law, grounded in widespread international practice.
But your challenge is to Article 3,
Yes, that's right. I'm going to come to that in a moment.
not to a wider principle
That's right,
of
because
customary international law.
of course, what's at issue here is about two pieces of domestic legislation. And ultimately, one piece of domestic legislation is drawn from the ECHR, one piece of domestic legislation is drawn from the Vienna Convention.
So rather than it being the case of belittling, in fact, we've got to make sure we are focused on Article 3
Yes.
and not on the broader principle. That's what you've got to show
Yes,
is incompatible.
yes, that's right.
And that includes, and no doubt you'll come to this, the interpretation of Article 3 in the European Court.
Yes, and indeed the interpretation of Article 3 and the positive obligations of the domestic courts, although we've very limited case law in relation to that aspect. But at international level, my lord, and then reflected, as we'll come to in Strasbourg, is that the prohibition of torture also imposes an obligation on states to ensure that they have effective protection from torture, including effective protection from torture, inhuman and degrading treatment imposed by third parties. And so, my lord, we then, under the convention, the ECHR, Article 1, of course, requires that the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this convention. And the reference in the authorities is to page 2291. And Article 3 of the European Convention includes an obligation to secure an individual's right to freedom from torture, inhuman and degrading treatment, including the obligation to take effective measures to prevent the commission of private acts of torture or inhuman or degrading treatment. And the particular authorities in the bundle for you on that point are Z and the UK, paragraph 73 in particular, its authorities bundle, page 1008. And you find that it's volume C, tab 20, for those in the hard copy bundle. And the A case, at paragraph 22, that's authorities bundle, page 923. And that's contained in the same volume at tab 18.
I mean, if we're looking at Z versus UK, page 1008, what it actually says is the obligation to secure everyone requires states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture, etc., including ill treatment by private individuals. These measures should provide effective protection, in particular of children and other vulnerable persons, and include reasonable steps to prevent ill treatment of which the authorities had or ought to have had knowledge. And I think that's probably common ground, isn't it?
Yes, and my lord, that phrase, effective protection, in paragraph 73, you'll have seen we rely upon that, as does the local authority. And the thread running through the cases on positive obligations under Article 3 is the concept of effective protection. So the subsets which you then have to the different specific positive obligations are all under that umbrella heading of measures being required to provide effective protection, in particular, of children and other vulnerable persons. So that quote in paragraph 73 of the Z case is repeated in a number of the other authorities.
What was the A reference you wanted to?
The
Noted
A
that.
case it's page 923. So that's in the same authorities bundle, tab 18. Now, and this is why, my lord, I began by referring to the international recognition, because the Strasbourg cases repeatedly refer to the international recognition of this as a fundamental concept under the ECHR. Now, A in the UK is, of course, the case involving a violation of Article 3 after the applicant had been beaten by his stepfather with a garden cane. The stepfather was acquitted, relying on the pleading of reasonable chastisement. So a very different set of facts. The nature of the beatings in that case fell within Article 3. See paragraphs 39 to 41. That's authorities pages 9, 13 to 14. And again here, there's no dispute between us, and it's recognised, and there's no challenge to it, that the conduct here also falls within Article 3. The key paragraphs are paragraphs 48 to 50 about the nature of the obligation. And it's page 916 to 917.
Well,
and you see the reference at the bottom of paragraph 48 to the need to provide practical and effective protection. So those phrases, effective protection from the Z case and practical and effective protection in the A case, run through a number of the other authorities. And I know that the local authority is likely to take you to some of those other authorities which pick up that phrasing. But that's the overall phrasing describing the positive obligation under Article 3. And the analysis by the European Court of Human Rights in the A case refers at paragraph 49.
Sorry, that's in the Commission's opinion, just so you note that.
Yes.
Hence the
That,
bold,
yes.
hence the bold paragraph numbers.
Yes. And it's in slightly different
Yes, that's right.
terms. In the judgment it says effective deterrence.
Yes, that's right. That's right, my lord. Apologies. I'm not following my own note effectively. That's correct. So the phrase that's used by the Commission is practical and effective protection. And what you then see in the judgment is
there's
that
no
reference
material
to
difference.
effectiveness. Apologies, my lord, I'm sorry.
There's no material difference
No,
between
there
these
isn't.
various formulations. I mean, I'm not sure it helps to see it written out half a dozen times. It's the same.
But my lord, when you then turn to looking at the specific positive obligations which arise under Article 3 and that have been developed in the case law, it's against that backdrop about the fundamental nature of Article 3's protections and the importance of effectiveness, the obligation to ensure that there is an effective system for protection.
The real question is whether it's qualified by a requirement of reasonableness.
Well, my lord, we don't accept that. That's the argument which is made by my learned friend. And the
Well,
issue
I
here
mean,
is what
the-
reasonableness means. Because, of course, apologies, go ahead.
I mean, the point I'm putting to you is whether the words qualified by a requirement of reasonableness are the correct words or not. The statement that measures should provide effective protection and include reasonable steps to prevent ill treatment of which the authorities had or ought to have had knowledge is all about a value judgment as to what is effective in the circumstances. And even the term effective deterrence, there can't be a duty to prevent absolutely any ill treatment, because we know that children are ill-treated, unfortunately and very sadly, all day long by their parents, whether diplomats or not. So what we're looking for is what is the true obligation under Article 3, which you say is truly incompatible and irreconcilable with the Diplomatic Privileges Act. And at the moment, I don't see that this obligation, this is too much of it's too diffuse.
So, my lord, what the cases say is essential is effective protection. It's quite right that there isn't an absolute obligation in the sense of it necessarily requiring an outcome, because there will be certain circumstances, and we see this from the Osman line of authorities under Article 2, there will be certain circumstances in which there are measures which simply can't be practically taken, given the unpredictability of human behaviour and so on. What we're dealing with here is rather different, and that's why the way we put the case under Article 3 is that this is a breach of the system's obligation under Article 3, the result of which is that in individual cases, state authorities are prevented from investigating where there's credible allegations of conduct which is violative of Article 3, as there was here. And state authorities are also prevented, including the courts, and Mr. Justice Mostyn in this case, from taking the protective steps which they would otherwise take. But the case law which concerns the protective or operational obligation and the investigative obligation tends to arise in the context of specific individual cases. And if this was a civil claim, or indeed if this was a judicial review, it might be put in that way. But this case is about the bigger picture, which is the system, meaning that for AG, for AG's siblings, and for any other children within that 23,000 who may be subjected to, where there's credible suspicions of conduct which is violative of Article 3, whether that be a child being raped behind closed doors, a child being sexually abused behind closed doors, a child being physically assaulted behind closed doors. In all of those circumstances, what we say is at issue is a systems breach which necessarily results in it being impossible for there to be effective protection for children in that category, because of the non-applicability of Parts 4 and 5 of the Children Act and the compulsory provisions in the Children Act 1989 to this very particular group of children. Now, the system's duty as described in the Divisional Court judgment is described in very narrow terms. That's simply having a framework of laws.
So I think, if I may say so, just before we come to what they described, your case is that what is required is the provision of effective protection and effective deterrence, C, Re Z and Re A, and that the breach in this case, in other words, the failure to allow investigation of diplomats' circumstances and the failure to allow effective steps in court, gives rise, necessarily results, in there not being effective protection for those children.
Yes.
And that is the long and the short of it.
Yes, it is.
Yes.
Yes, it is, my lord. And that's why when you ask the question about reasonableness, the reasonableness question we don't think particularly helps here, because the reasonableness question as framed by the Divisional Court and as framed by the Secretary of State is framed in a circular way. Would it ever be reasonable to require a state authority to breach the Vienna Convention and to breach the principles of diplomatic immunity? Of course, if you ask the question in a different way, would it ever be reasonable for the best interests of children to be disregarded or for children to continue to be abused behind closed doors, you get quite a different answer. And the other reason why it's not helpful is that here, this is not a case where it's a challenge to, as you would have in a civil claim or potentially in a judicial review ordinarily where this might arise. It's not a challenge to individual decision making in this particular case. It's not about, did the London Borough of Barnet do all and take all measures that were reasonably available to it in the circumstances. It's not a question of whether the Metropolitan Police could or should have done more, because both the London Borough of Barnet and the Metropolitan Police, and indeed Mr Justice Mostyn and the High Court and the Divisional Court, had their hands tied because of what we say is a higher level failure, a systems failure.
So
that's why we've put it in that way.
I mean, I completely get all that, Ms Gallagher, and I think it's a very simple submission that you've made, which is that the systemic breach, in other words, the failure to be able to take the measures in the Children Act, as discussed, necessarily result in there not being effective protection for this kind of child in this situation. Good. The answer to that, which you have to deal with, is that there is a criterion which says that you can only take steps which are reasonable in the circumstances for the authority, the state authority, the state to take or the court to take in your argument. And it is not reasonable to drive a coach and horses through the Diplomatic Privileges Act, which is long established, etc., existed at all times before this, and would give rise to, as the evidence from the Secretary of State says, massive reciprocal reprisals and impossibility of diplomatic activity worldwide. We can take examples which would probably be invidious of countries where our diplomats would be at risk. Now, Sir James has to make that point good. You say it's an absolute, insofar as it is a requirement to provide a system that is absolute, and it doesn't matter whether it's reasonable or not. But he says, well, that just departs from reality, because this article is only about taking such measures as the state can take. And that's why, just to put the point to you, that's why it says when the state knows. Because, for example, you can't be criticised if beatings or abuse is taking place behind closed doors, as it so often does.
So, my lord, it won't surprise you to hear that I don't accept that characterisation of our case.
Right.
We are not presenting our case by saying this is an absolute obligation in which, in every circumstance, there must be an outcome of result, and individuals and entities must behave in an unreasonable manner. It's simply not our case.
Do say, but I understand you're not saying that, but you do say that there is no qualification of reasonableness. It is a breach of the system's obligation if you cannot take, in appropriate cases, investigatory steps, and if you cannot take, in appropriate cases, court prevention of bad things.
So, can I answer that in a number of ways? The first point is that the case law focusing on reasonable steps and so on tends to be at this lower level, relating to individual decision makers in individual cases.
Operational duty, operational, not systems. Is that what you're saying?
Yes, precisely. Operational and protective and investigative.
But is it your case that the systems duty is not qualified in the way that my lord has posited?
No. So I'm sorry that I haven't been clear on this. So on the systems duty, first of all, we say that the requirement is a general positive obligation to establish a framework of laws, precautions, means of enforcement which will prevent the occurrence of torture, inhuman or degrading treatment to the greatest extent possible. That's what we say the systems duty
Sorry,
is.
could you just, have you written that down? Is that from your skeleton?
We do use that phrase in paragraph 33 of the skeleton.
Well, would you mind just going,
Of course.
so I can write it down?
So we say
General positive obligation.
there's a general positive obligation, this is the systems duty in this case, to establish a framework of laws, precautions and means of enforcement which will prevent the occurrence of torture, inhuman or degrading treatment to the greatest extent possible. And we do not advance an argument that there's no qualification or requirement in respect of reasonableness. We don't do that. And we can see it's put in that way against us in the Secretary of State's skeleton. It's suggested that both we and the local authority have argued that, but in fact that's not how we've argued it. Where we do differ is on what reasonableness means in this context.
Where do you, that phrase that you read out, or that definition or whatever it was, is that you or is that personal authority?
So it's drawn from the authorities that we've summarised in the skeleton argument. And that starts with that general positive obligation. One of the difficulties, my lord, is that many of the cases relate to Article 2, and there's very limited cases related to Article 3.
Whereabouts in your skeleton are you?
So that phrase is from paragraph 33 of our skeleton. And you see the background analysis with reference to the international materials from paragraph 17 onwards, and then the particular phrases which are used in the Strasbourg authorities in paragraph 20, 21. And of course, in those cases, specific reference is also made to the particular position of children.
But I mean,
and the importance of apologies.
I mean, you've given. We've read your skeleton. We've seen the authorities, but the problem to me is the duty you posit. You say it's a general positive obligation to establish a framework of laws, precautions, and means of enforcement to prevent ill treatment to the greatest extent possible. Well, on one analysis, that has been done. The question is whether that must be applicable in every case, irrespective of other international norms under international law. And that, what you're saying is, seems to me relatively uncontentious. But the problem is, in the words, to the greatest extent possible, because that's a sort of value judgment. I mean, there's never a system which is to the greatest extent possible, particularly in this area, without surveillance of people's homes and things of that kind. So what does that mean? And are there any exceptions? And you accept an exception for reasonableness, but that's not in your formulation. So what is the exception for reasonableness that you accept?
So, my lord, that phrase, to the greatest extent possible, we acknowledge, of course, means that there will be some limitations to it in certain circumstances. Where we differ, and this is why we've described reasonableness as a red herring in this context, is it's all about how the question is phrased. It's rather like one of those circumstances where someone gets asked a question in a survey and the question is very heavily loaded. The question as it's put by the Secretary of State in the Secretary of State's skeleton is presented in a circular way. The argument that's put is it cannot conceivably be interpreted as requiring member states to adopt a system which would require them to breach the obligations set out under the Vienna Convention, under the VCDR.
Yeah,
That's
I
what they
know
say
that,
it.
but what do you say? I know what he says, and let him say it in due course.
Of course.
I either agree with it or not, but what do you say is the qualification? You answered my question very fairly by saying we're being mischaracterized. We don't say there is no qualification. What do you say the qualification as a matter of law is under Article 3?
So, as a matter of law, it's...
On the authorities.
As a matter of law, it's to the greatest extent possible to ensure that the system overall is effective and results in effective protection. And our submission is that a system
hang on,
which
but
means...
those are more words. Do we put those at the end of what you say? So do we now put to the greatest extent possible to ensure that the system is effective and to ensure effective
No, my lord.
protection.
I'm simply answering your question.
Right.
So, to your question, we have said the touchstone is effective protection. Now, effective protection, effectiveness, of course, may mean that you have a system which nevertheless results in some individuals falling through the cracks, despite having a system which is overall effective. The scenario we have here is very different. The scenario we have here is that thousands of children, as a result of their status, are excluded entirely from the protective system. And in our submission, it cannot sensibly be said that there is effective protection for children like AG, for diplomats' children, under the child protection scheme in this country as matters stand. And
Where does the phrase "to the greatest extent possible" come from? I think I asked that. Is that in the authorities, or is that
Yes,
your? Is that your definition?
Yes, it is. It is in the authorities, and I can get you some of the best references. I'll do that over lunch rather than taking time now, given the timings.
I mean, possible is doing the work in that sentence, isn't it?
Yes,
As
but
opposed to
similarly,
reasonable.
of course. But similarly, when you talk about effective protection, which we've seen the reference to, the references in the cases to effectiveness, which is the phrase which repeatedly gets used in relation to effectiveness, we recognise, of course, that the concept of effectiveness internally necessarily will mean that there are some circumstances in which it may not work for an individual child. This is quite different. What we're dealing with here is a situation in which there's a category error and the entirety of this class of children, diplomats' children, that proportion of the 23,000, are simply outside the scheme at all. Now, the divisional court's response to that and the Secretary of State's response to that is to say, in fact, the framework is effective. Now, that's what's said. So, on the divisional court's analysis, the divisional court, it's paragraph 113 of the judgment, core bundle page 65.
Well, they say, both of them say, it's effective to a point. It's effective to a point, and it's effective as it can be, where you have to align the legislation and the concerning diplomats with the legislation concerning child protection. And you've given me a partial answer. You say the touchstone is effective protection, and we accept some individuals will fall through the cracks, so that much is a reasonableness exemption, but you can't have a category exemption, right? But you're not tackling the point that is made against you, I think, which is that there has to be, and there is nothing in Article 3 that prevents different situations and levels of protection for different categories where you have something as ubiquitous as the protection of diplomatic immunity. So, there's a sort of complete disconnect between your argument and theirs, because you say this is not effective protection, obviously correct in this case, or not as effective as it could be, obviously correct in this case. They say, but we can't go any further because Article 3 does not demand that you throw out diplomatic immunity. And what do you say about that? Do you say that you have to? Diplomatic immunity is not sufficiently important to be relevant here because of the importance of the rights of the child, etc. Or what do you say?
Yes.
Mr. James says, well, this is not reasonable, and that's an additional qualification of reasonableness you have to read in. And Article 3, what's strange about Article 3 is that we're coming a mile away from the words of Article 3.
Well, this is the textual
in
approach.
this debate.
This is the textual approach which was adopted by the divisional court below. But it's clear from the authorities that effective protection, a positive obligation to ensure effective protection, is inherent in the concept of freedom from torture, inhuman and degrading treatment. That's clear from the line of authorities. Now, I entirely take the point, my lord, about, in essence, us being two ships passing in the night. or if I may, 3 ships passing in the night, which is part of the reason why I was reluctant to engage with the question about the way it's put against us, as if we're somehow suggesting reasonableness doesn't come in, which is not what we're saying, and we're simply saying it's a red herring that doesn't get to the heart of the case. The position which we adopt, as supported by the local authority, is that in these circumstances, for this category, there is no effective protection in violation of Article 3. Now, the points which are made against us, including the points to which I'm sure Sir James will come, and to which Lord Sumption made reference in his minority judgment in the Reese case, about what will happen if there's some form of carve-out, we say ultimately are questions for the legislature to decide. They're policy questions. You don't have the evidence before you about what precisely would happen and whether the chicken licken submission would in fact come true. You don't have that material before you, and that's not something appropriately, we suggest, to be dealt with in the court. In court, we say the question is there currently a system in place which satisfies the requirements of that general positive obligation, the system's obligation under Article 3? Now, what the divisional court said on that issue, the divisional court said the measures available to the local authority, absent any of the ordinary compulsive powers which you would have in other circumstances.
Which paragraph?
So, in the judgment, it's paragraphs 94 to 97.
I mean, this is the critical paragraphs of the judgment.
Yes. So, paragraph 94, they say the legal framework represented by the Children Act represents a system which complies with the requirements of Article 3.
Will you agree with that?
Yes, in general, yes. And then, of course, there's the reference to Article 41 of the VCDR. Those who enjoy diplomatic immunity in the UK are nonetheless not free from an obligation to comply with those laws, because you're still obliged to comply with laws. The issue is...
Yes. Well, Article 41 says you have to comply with the culture and laws of the country.
Yes. And that's why when you have a scenario like the drunk ambassador in the car, there's a ready way of dealing with it, because without prosecuting the individual and taking criminal action against them, you can have him temporarily removed from the car and in a situation where he sobers up until the risk is dissipated. Or indeed, if you have a protester whose life is at risk on the roof of an embassy, you can have them removed from that scenario.
So then 94, 95, 96 talks about the limited effectiveness of the measures that were taken. So says it's not that there is no effective protection, it is that there is lesser effective protection for diplomats. And then we get 97, which is that they rejected the submission you made, that, or your side made, that a blanket excision is to be made in practice from the ECHR in respect of diplomats, and that's just making good the rest of the point. And then the key to the judgment really is in 98. So they conclude that in the light of that analysis, it's our judgment that there is no conflict between the Convention and the DPA.
Yes.
You say that's wrong.
Yes. So, my lord, I agree that paragraphs 94 to 98, you read them as a whole. So paragraph 94 refers to the general legal framework represented by the Children Act, representing a system which complies with the requirements of Article 3. We agree with that. Reference to Article 41, that those who enjoy diplomatic immunity in the UK should be complying with those laws.
But what I think they're saying in 98, which is the key to the judgment, is there is no authority in the European Court of Human Rights or elsewhere that construes Article 3 as requiring a breach of the DPA or the Convention, and therefore see the latest cases in the Supreme Court, the initials of which I always forget, SG or GS or RC or whatever it is, that means that we can't go further than... Sorry?
AB, isn't it?
Yeah, probably.
I think you're referring to AB, the solitary confinement case.
Forgive me, I'm not very good at initials. It's lucky I wasn't a family lawyer, Miss Keller.
Well, the first case before the Supreme Court, of course, referred to alphabet soup.
Yes.
We do have many of those cases in the bundle before you.
But the serious point is that the Supreme Court has said we can't go beyond the European Court of Human Rights because there's no possibility of the government appealing to the European Court of Human Rights. And since there's no case which says that Article 3 requires us to drive occasion horses through the convention, we shouldn't. Now, what's wrong with that argument?
So, my lord, may I turn to that question, essentially about the Ula principle and what's said in AB in a moment. But first, may I just deal with these points, paragraphs 94 to 98, because we agree they're at the heart of the judgment. I want to ensure that there's no misunderstanding about what our submission is. So, in respect of paragraphs 94 to 98, what is said there, as you see from the first sentence of paragraph 98, is, in the light of that analysis, it's our judgment that there's no conflict between the ECHR and the DPA VCDR.
Well, that is quite a... One could put that sentence in square brackets, I think.
Yes, I'd be interested.
So just go on.
Of course. Because the context is, when you then look back at this section, what's said here is that there are some practical measures which are of some value. That's the phrase used in paragraph 94. And then paragraph 95, there's this phrase which I turned to right at the very outset of my submissions, which says, the steps taken have achieved directly and indirectly protection for the 4 children still in the UK. This position was achieved, albeit not as swiftly as would normally be required, perhaps in the nature of the task, by seeking agreements, a waiver of immunity, and then by declaring the diplomat and family persona non-grata. And if I may, our submission is there is an air of total unreality to that description at paragraph 95. And similarly, there's an air of total unreality to the submission.
Let's assume you're right. Assume you're right, that is understatement, and that you're right, what's happened is terrible and not good enough. But we still have to tackle the point in paragraph 98.
I agree, but the point is that you can't simply look at the phrasing in paragraph 98 without looking at the analysis conducted by the divisional court.
No, I mean, your point, let me say what I think your point is. I think your point is that it is simply wrong to say that it is a sequitur, that because there is some effective protection, there is no conflict between Article 3 and the DPA. There is a clear conflict between Article 3 and the DPA because you cannot provide effective protection for children in this category, as you've explained in your reasoned argument, and therefore you have to tackle the $64,000 question, which is not that there is some effective protection and that's good enough, because it's not good enough, but does it matter that there is a DPA, which is a long-standing application, which has always carved out diplomats from doing terrible things, by the way, not just abusing children, also murdering people and stealing and doing all sorts of other very bad things. And does it matter that that is an international norm? And does it mean that Article 3 can override all those other international norms when all it says is you must prevent torture, etc.?
Yes. So, my lord, just taking that in stages. Firstly, and I won't labour the point, given what you've just said, our submission in relation to those paragraphs is that the analysis by the divisional court was fundamentally flawed in suggesting that there was some protection or somehow that the system worked well here. The system, to the extent that anything happened here, was a child who should have been removed and would have been removed in January 2020 remained in a situation of abuse until she escaped through a back door in April 2020.
You're pushing as an open door, as far as I'm concerned, that saying that the system worked is just simply not true. It did not work to a satisfactory level.
Yes.
The question is whether Article 3 says it must.
I agree. And my lord, but the divisional court's analysis, which leads them to the point of saying, and perhaps this is why square brackets would be essential for this section to make any sense, when you get the first sentence of paragraph 98, in the light of that analysis, it's our judgment that there's no conflict between the ECHR and the DPA or the Vienna Convention. It's quite clear that the divisional court was working from the basis that in fact there had been some effective protection here, and the system in some way worked here, albeit that it was not as swiftly as would normally have been the case. And that's a mischaracterisation of what in fact happened here. And it's a mischaracterisation of what could happen in a wider range of cases. Paragraph 98, what we then get is the analysis which we say looks at the issue simply from one end of the telescope in a way which necessarily results in a loaded answer. What the divisional court says is that the Strasbourg requirement for a legal system to be in place to protect children through legislation, investigation, and then the taking of other measures cannot be read as also requiring the UK and other Council of Europe member states, all parties to the VCDR, to adopt a system which would require them to breach the VCDR towards each other and to other states. The ECHR does not require that in its text. There's no jurisprudence which requires the contracting parties to breach the VCDR in order to avoid a breach of the ECHR. Now, there's no authority on this point either way, which is why we started by saying this is essentially a blank slate type case. And that is why, at the heart of this case, is the question of whether there is a way in which Article 3 of the ECHR's requirements and Articles 31 and 37 of the VCDR can be read in a compatible manner. And there's a separate later question about what the appropriate relief might be in the event that you agree that there simply isn't a way of reading those compatibly.
So the word there in 98 that's doing the lifting is cannot. It just say it cannot be read as requiring, line 4.
Yes.
So in answer to your question, using your phrase, whatever your phrase is about possible, or by all means possible, they're saying it's not possible.
Yes.
And your point is that 94 to 97 and the first part of 98 doesn't lead to the conclusion of the first sentence of 98.
Yes.
But as my law's pointed out, it's really the rest of 98 that you've got to
Yes.
face up to.
And this is where we're in the ships passing in the night analysis, because what you have from the other side is you have the argument that it could never be considered reasonable or it could never be considered appropriate to require a state to breach the VCDR. And what you have from us and from the local authority is, well, in fact, you could phrase the question quite differently, which is it could never be said to be reasonable to require a member state to adopt a system which requires them to violate clear requirements of the positive obligation under Article 3 ECHR and result in lack of protection for children. And this is in circumstances where, when you look at those two Supreme Court cases and the reference to the international recognition over a period of time about the unacceptability of human trafficking and the need to do something about it, the due diligence obligation into human trafficking, that's why the analysis which the local authority below put before the court regarding the importance of the UN Convention on the Rights of the Child is so important, because the local authority in its analysis below, and indeed supported by AG with a different legal team, made the argument that there now is a recognition of best interests of the child and the importance of effective protection for the child, which is in a similar category to the recognition of the position in respect of trafficking. Now, may I deal with the point, my lord, you asked me earlier about essentially the Ula principle question, if I can put it that way. And we don't have Ula in the bundles, in any of the versions of the bundles, but of course we're all very familiar with the phrase about the duty of the national courts being to keep pace with the Strasbourg jurisprudence as it evolves over time, no more, but certainly no less. We have given you in the bundle this morning the D case, which I know was, and that was agreed between ourselves and the local authority, but we thought it would be helpful for you to have that. Given that it's one of the few cases which concerns positive obligations under Article 3. when many of the domestic cases concern the analogous provisions in respect of Article 2. You've got Rabone and so on in the bundles before you.
Page 42, is it?
Yes.
In the second supplemental bundle.
Yes, that's right. Now, or for those of you who are working from the tabs, it's the third tab in that supplemental bundle. That's tab 68. Now this, of course, is the John Warboys case. So the Metropolitan Police appealed against a decision that there'd been a breach of Article 3 rights of the respondent women by failing to conduct effective investigations into sexual assaults committed by a serial offender, and the women were among many who'd been attacked by the black cab rapist John Warboys over a 6-year period. The state was under a general duty to investigate ill treatment amounting to a violation of Article 3, and it was found by the judge that there'd been systemic and operational failures by the police in their investigation that amounted to a breach of the women's Article 3 rights. And the Supreme Court in this judgment dismissed the Metropolitan Police's appeal, holding that the Human Rights Act imposed on the state a general duty rigorously to enforce laws which prohibited conduct constituting a breach of Article 3 of the Convention, so as effectively to deter such conduct, which required that complaints of ill treatment amounting to a violation of Article 3 be properly investigated. And the focus of this case is on the investigative obligation, so specific aspect in the individual case of the positive obligation. But in relation to the mirror principle, or the Ula principle, there's analysis at paragraph 73 by Lord Kerr. That's internal page 223.
Was he in the majority?
Yes. So you see the heading, should the question be left to Strasbourg, paragraph 73 onwards. And the argument which was made here, as you can see, captured, it was strongly argued on behalf of the Secretary of State that the question of whether a liability such as that contended for by the respondents, whether that arises, was one on which the Strasbourg court should be invited to pronounce. And the subtext to this argument appeared to be that where Strasbourg has not yet spoken, national courts should not venture forth. And you see paragraph 74, which refers to that argument carrying echoes of those which found favour in cases such as Alscaney, Ambrose and Harris. And then paragraph 75 to 79 is the analysis by Lord Kerr of the difficulty with that approach in circumstances where you're dealing with a blank slate issue, as indeed the divisional court was here. And at paragraph 77, Lord Kerr refers to how in Rabone, which you also have in the bundles, the view in that case regarding the obligations under Article 2 of the Convention was a decision reached notwithstanding the fact that there was no authority from Strasbourg to that effect.
So it's all Obiter because he thought the jurisprudence was clear and constant.
Yes. And my lord, you'll see there is also a paragraph 152 from Lord Mance.
He was in the minority.
Yes, he was. You see there's some analysis of paragraphs 152 and 153 of Lord Mance. But our key points in respect to this issue are that first, the mirror principle as encapsulated in the Ula case and Lord Bingham's dicta has been departed from in a series of other cases. See Rabone, paragraphs 111 to 114, or those paragraphs of Lord Kerr in the D case. And when you look at the phrase that's used in the AB case in the Supreme Court.
Well, I was going to say how you're going to deal with that, because
Yes.
that's the latest, Supreme Court latest.
Yes, it is.
So I'm at page 766 of the authorities bundle. Is that the key part of AB?
So sorry, my lord, just...
Paragraph 54. Not the function of this court. Will agree to undertake a development of the convention law in such a substantial nature.
Yes.
So, yeah.
Sorry, 54, page 766.
So it's bundle 1 for those of us in old money.
He says at 58 it's been repeatedly endorsed at the highest level. And this is the, and I take it Lord Reed is in the majority or the only judgment in AB.
Yes, that's right. And the phrase that's used that reliance is placed upon by my learned friend for the Secretary of State is the reference to whether the domestic courts, if they go further than they can be fully confident that the European Court would go.
Yeah.
That point. Paragraph 57, that's the phrase that's used. Now, the context of AB is very important because in the AB case...
And they talk about incremental development
Yes.
being involved in Rathbone, Raybone and other cases.
Aren't isn't what you're doing the same as what the appellant was doing in paragraph 60? Or same as characterised by Lord Reed in paragraph 60, which
No.
he was emphatically saying wasn't open to the Supreme Court.
No, very much not.
Okay.
So the AB case is quite a different scenario, and you see that from the start of Lord Reed's judgment, if you go back to page 750. So our submission is that we are much more in the territory of Rabone, of the D case, where you're essentially dealing with blank slate. This is a topic which has not yet been decided by Strasbourg, but there are clear indicators in the Strasbourg case law about the approach that will be taken. AB is a very different case.
Well, look at paragraph 60. What you're doing, and please tell me if I'm wrong, I'm just thinking you may be doing, is inviting us to adopt, your submissions are based on a principle which ought now to be adopted in the light of a body of material concerned with other international instruments. In particular, you're talking about the universality of the recognition of the iniquities of child abuse recognised in instruments we're going to come to later on.
May I show you, my lord, why AB was a very different case? So in AB, if you go back to page 750, the start of the majority judgment, start of the judgment of Lord Reed. Do you see at paragraph 1, this appeal raises two questions of law. And the issue in the AB case was that the appellant's argument was that there was a per se breach of Article 3 once you had solitary confinement of a child for a certain period of time, regardless of circumstances, and there should be no case-sensitive analysis. And you see from paragraph 2 that Lord Reed, and indeed in a unanimous judgment for the court, the appellant doesn't raise any wider questions than those set out above. So the only questions which were put forward by the appellant were these questions. And there was no argument that the appellant's treatment violated Article 3. Instead, the argument simply was that there was a per se breach. And the argument was in terms that it was inappropriate to carry out an assessment based on the facts of the individual cases. And you'll see at paragraph 3 that the Supreme Court declined to consider the individual circumstances because the appeal had been put on this per se basis. What you then get when you look at the judgment as a whole is you see that the argument that was advanced ambitiously by the appellant was that despite the line of authority in Strasbourg, clear line of authority in Strasbourg on Article 3 being case sensitive, in this case the Supreme Court should adopt a wholly different approach.
Okay, so you're saying this isn't the blank slate which you say we're looking at here.
Yes, that's exactly right. And you see that if you look at under the heading discussion, at paragraph 50 onwards, page 765, there's reference to there being a consistent approach to the application of Article 3 in the European Court of Human Rights cases. It's a fact-sensitive test, whole range of cases including Grand Chamber cases which adopt that approach. And the argument which was being made by the appellant in this case was, in fact, that the Supreme Court should adopt a wholly different approach. And for that, they were placing reliance on international instruments to encourage the court to take a view which was very different to the Strasbourg approach. So that's the context in which they were relying on UNCAT. That's the context in which they were relying on the UN Convention on the Rights of the Child, the Beijing rules, and so on. So it's a wholly different scenario. So when you then see that analysis at paragraph 60, my lord, which you've put to me, where it says he's not inviting the court to decide the appeal on the basis of principles established in the case law of the European Court, but on the basis of a principle which he argues ought now to be adopted in the light of a body of material concerned with other international instruments. What's important to bear in mind is that the start of that sentence, he's not inviting the court to decide the appeal on the basis of principles established in the case law of the European Court. What that's referring to is, in fact, the appellant's argument was adopt an approach which drives a coach and horses through Strasbourg's approach to Article 3. Adopt a wholly different approach. It's not the scenario that we have in Rabone or in the D case, where there are principles in the case law which are applicable in our scenario, which is as yet untested. Because the issue simply hasn't come before the Strasbourg or the domestic courts. So our submission is that the correct approach here is the courts should aim to keep pace with Strasbourg, particularly where there's a clear and constant line of authorities which can be followed. But because the rights under the Human Rights Act are domestic, they must be given effect according to the correct interpretation of the domestic statute, in this case, the Human Rights Act. And we make reference there to Lord Kerr in D, paragraph 75. And where there's no directly relevant decision of the European Court of Human Rights, as in this case, with which it would be possible to keep pace, our submission is that the courts have a statutory obligation under Section 6 of the Human Rights Act to decide whether a convention right has been violated, even if this means going beyond Strasbourg, but beyond suggests a decision to depart from Strasbourg approach, whereas here it's a blank slate case. So very different to the AB case, where what the appellant was urging was an approach which would take a different turning to the Strasbourg approach. And that was rejected rather comprehensively by the unanimous court in Lord Reed's judgment. So what we come back to is the core question, which is whether we're dealing with a situation where there is an irreconcilable clash between the Vienna Convention and Article 3. And in our submission, there is an irreconcilable clash between the Vienna Convention and Article 3. The way the court got to its analysis below was to say, well, there was a form of effective protection, so there's no irreconcilable clash. We say there is an irreconcilable clash, and you've heard my submissions as to why the analysis of paragraph 94 up to 98, the divisional court, is flawed. In addition, the divisional court took the view, also in that section, or paragraph 96, that the Secretary of State steps declaring a diplomat to be persona non grata gives some practical effect to the Article 3 obligation in respect of these children. And again, that's not a submission which we accept, nor does the local authority accept it. On the contrary, our submission is that AG's younger siblings too young to escape in the way that she did, then aged 9 and 5, were removed from the jurisdiction by their parents on the 18th of April and are now in a situation where they are back with there being zero evidence before the court of any protective steps having been taken. Now, just want to deal briefly with the point regarding the Chahal and Suring line of authorities that's made against us by the Secretary of State. So the Secretary of State's argument on this issue about the non-refoulement point it is in essence that the onus is on the individual to provide evidence. And we see that from paragraphs 53 to 55, 53 to 54 of the Secretary of State's skeleton, where they refer to the Chahal principle and say the Chahal principle applies if a child is returned only where the authorities of that state are unwilling or unable to protect the child. The European Court of Human Rights requires an individualised case-by-case analysis of whether the evidence demonstrates that such a risk exists, and they make reference to Chahal, to Sadi. Now, our submission on this point is that that is not an apt analogy. Chahal, Suring, Sadi, that line of authorities are wholly different to these circumstances. In circumstances like these, where the diplomat is declared persona non grata, as here, the Secretary of State necessarily has knowledge of ongoing ill treatment within the family household and of a real risk that would continue on return to the sending state. That's the very basis of the persona non grata declaration that they made in this instance. So suggesting that case law from a very different context should apply here simply doesn't follow. And here, our submission is, it's not for AG or her siblings to demonstrate risk in the way described in those other cases dealing with quite a different situation. The risk is already known. The measures
the question is not whether the risk is known, but whether the sending state's laws, procedures were insufficient to protect the child, and on that, the children, and on that, what the Secretary of State is, there is no evidence.
Yes.
Unsurprisingly, because this point wasn't taken below.
It's a point against them, because it's a point against them rather than against us, because here in circumstances where the risk is known, and where there's a declaration of persona non grata arising from that risk, and that declaration of persona non grata inevitably results in the return of a family to the sending state, would indeed have included my client being returned had she not made good her escape. The Secretary of State says there are remedies available in these circumstances, but there's zero evidence before you of the Secretary of State having taken any attempt to mitigate that risk or to make inquiries even as to whether the sending state was willing and able to protect the children upon the family's return. Now,
right, so you say that the onus to produce evidence was not on you, your client, but on the Secretary of State.
Yes.
On a point which wasn't taken.
Well, so on this point, the evidence, there's no dispute, I don't understand it to be in dispute, that there were no steps taken to engage in the kind of dialogue which you might have, for example, in circumstances involving an extradition in relation to assurances from a receiving state. What happened here simply is that persona non grata declaration is made and there was no engagement with the receiving state. Now, this doesn't go to the point about the declaration of incompatibility, because this is
an agreed fact between you that there was no discussions.
I don't believe there to be any dispute about that.
Well, that's not that's a controversial way of putting it, because as you're aware, there was engagement with the sending state about why they were inviting that sending state to withdraw the diplomat, and about why it was that persona non grata then followed. So they were aware of the risk. because that was the basis on which that diplomatic action was taken.
Yeah.
So the issue here, and the reason that we raise this, my lord, is, and this of course doesn't in fact go to the core question before you, which is about whether there's a declaration of incompatibility. This, really what this relates to is the fact that within the existing scheme, the state's hands are tied and there's very limited steps that they can take. If you're dealing, for example, with a scenario like the HH case, so the children whose parents are being extradited, which we've included in the bundle for completeness for you. If you're dealing with a scenario like that, where there's a state which is requesting extradition of a parent, there's an argument about whether the parent being extradited may result in an unacceptable breach of Article 8 of the children's rights because of separation from the parents. There's a process which can then be engaged in and material which can be obtained before the individual is in fact extradited. Similarly, if an individual's extradition is being sought to a country where, for example, they might be liable to the death penalty, there's a process whereby there can be an engagement and there's some leverage for the UK in those circumstances. There's zero leverage for the UK in these circumstances because ultimately you do not have a situation like you have in the extradition context, for example, or where another state is requesting evidence, where the UK can say, well, we're not going to proceed with the extradition, or we're not going to provide this evidence unless you comply with these conditions. This scenario is quite different, because in this scenario, the UK doesn't have that form of leverage present. My lords, just going back to, I went off a little just dealing with that non-refoulement point.
Sorry, one minute, a friend is pausing for a moment. Can I just give you one reference on the question my lords asked me? Page 52 of the supplemental bundle, you have a copy of the certificate that was provided under Section 4 of the 1964 Act to the sending state by Her Majesty's Government. And you will see the conduct there described.
So, my lords, this doesn't go to our point, which is you'll see from that document on page 52 to 54 that there's no engagement of the question of whether the receiving state or the sending state here, that the state in question, was willing or able to take any measures to protect. That's missing. What's described is the conduct and then explaining why the decision's been taken in respect of persona non grata. When we return to the analysis of the divisional court, but why the divisional court say you simply cannot read the ECHR Article 3 as requiring a breach of the VCDR, the submission which we have made and the local authority has made is that that is approaching the question in the wrong way. In these circumstances, our submission is that rather than asking, it's put very well in paragraph 60 of the local authority's skeleton, page 127, the question is not, we agree with this analysis, the question is not if faced with a conflict between obligations under Article 3 of the ECHR and the VCDR, which obligations should the UK comply with? The question is whether, from within the ECHR system, it's compatible with Article 3 to give effect to the immunities in the VCDR. And ultimately, the position which we've arrived at and the local authority has arrived at is that these are irreconcilable. And that's why the appropriate approach here in our submission is a declaration of incompatibility and the baton then being passed to the legislature to take a view about what to do about that irreconcilable clash. Now, the approach the divisional court took in paragraph 98 was to say there is no irreconcilable clash. And that's why that first sentence of paragraph 98 is so important. In the light of that analysis, it's our judgment that there's no conflict between the ECHR and the DPA VCDR. And that's why, despite my Lord the Master of the Rolls urging me to leave the point, we were so keen to make clear that that analysis in paragraphs 94 to 98 is wrong. Because that first sentence of paragraph 98, which says there's no conflict, is against the backdrop of the flawed analysis at paragraphs 94 to 98, which say the system worked here, the system worked for 4 of the children. And that is absolutely not an appropriate approach. We say the system here plainly was not effective. It was not effective for AG and AG's 3 siblings who've remained. It was plainly not effective for AG's 2 siblings who've left and who are now in this other state with their parents, despite the knowledge of abuse. And there's no evidence before you, and there was no evidence before the divisional court to indicate that the system, such as it was, and the limited steps which can be taken within the scheme, could, using the divisional court's analysis, paragraph 95, result directly and indirectly for protection for children such as this. So their approach was to say there's no irreconcilable clash, and that's then the context in which they go on to describe at paragraph 98 why they say you cannot possibly require the ECHR to be read in a way which would violate the VCDR.
Well, putting it another way, is your case that Article 3 mandates that the full range of our domestic, I emphasise, protective measures under the Children Act must be available to, accessible to, apply to the children of diplomats?
Where necessary to prevent a breach of Article 3. And that's why we did not deal with Section 17 and children in need, which we recognise as a different category.
Article 3, it mandates
yes.
the application of our domestic protective measures to the children of diplomats.
Yes. Because without that, there's no effective system for those children.
Well,
so what is
no
what mandate?
Domestic system available.
So what Article 3 of the ECHR requires is effective protection for that category of children. Recognising, of course, going back to my Lord's point from earlier, that there may, in any effective system of protection, nevertheless be some children who fall through the cracks who are not in fact protected. Which is why it's not an absolute in the sense of requiring a certain result in every single case. It requires an effective system of protection. Now,
but you say it doesn't depend on the individual circumstances of the case. It's a mandatory requirement that regardless of the circumstances of the case, regardless of what the sending state's laws are, what its situation is, it mandates in every case, as I say, the application of all our domestic law to diplomats and their children.
I may have misunderstood the question. By all our domestic law, do you mean parts 4 and 5 of the Children Act 1989, the compulsory provisions in relation to child protection?
In this case, yes, obviously.
Yes. Well, I should be careful not to misspeak on this because, of course, the scheme under the Human Rights Act is that if you find a violation of the system's obligation, the baton then passes to Parliament to take a view on how to resolve that. And in theory, it would be possible for Parliament to have a shadow alternative scheme, a scheme which isn't under the Children Act, but it is under some alternative piece of legislation. So the key question is whether there's effective protection. And Article 3 mandates that there be effective protection for that group of children. At present, that group of children do not have effective protection because they're excluded from the Children Act 1989. Now, the most obvious way to resolve that would, of course, be for there to be an exemption, an exception, which ensures that they are covered by those provisions of the Children Act 1989. But I just want to ensure I'm not putting something in an incorrect way when it's not for this court, or indeed for any of us as the parties, to prescribe precisely how the conflict be resolved. And I can see in theory there could potentially be an alternative way of resolving it, which involves an alternative scheme. The point is, at the moment, there's no effective system of protection. Article 3 requires an effective system of protection. And
this would cover all children at risk of significant harm?
Yes. Regardless of their status. In this case, their status as diplomats themselves or as children of diplomats, because diplomatic immunity extends to the children also. And we say that's mandated by Article 3 of the European Convention, and also by Article 1 in circumstances where AG and her siblings and the other children within that 23,000 are within the jurisdiction. divisional court's focus was to then look at what they described as the natural meaning of the text. And my lord, I'm conscious, and my lord, the Master of the Rolls referred earlier to being some distance from the precise wording of Article 3. But that is why, in our submission, the approach that was adopted was a flawed one in the divisional court, because a focus on the natural meaning of the text meant that an approach was adopted to Article 3, which was simply at odds with the approach adopted to Article 3 in the Strasbourg jurisprudence or in the case law domestically, including the D case. And that focus meant that there was a failure to engage with the significance of other principles reflected in Article 3, including principles of customary international law, prohibition of torture, and the now well-established principle about the rights of the child under Article 3 of the UN Convention. Because the focus was from the other end of the telescope. The focus was on the importance of the requirement to afford diplomatic immunity, Articles 31 and 37 of the VCDR, and the assumption, paragraph 98, you simply could not adopt an approach which failed to protect Articles 31 and 37. And an assumption that a system which took a different approach and had an additional exemption would not be contemplated. And running through the analysis in the judgment are those repeated references to Lord Sumption's analysis in the Reese case, where Lord Sumption referred to the fundamental difficulty if in fact an existing exemption in that case, the professional commercial activity exemption, were to be applied in circumstances to which the Supreme Court has now indeed applied it in July 2022. But it means that when you read the judgment, there was just a failure to engage with the importance of the points on the other side of the scales. Now, repeated references made in the Secretary of State's skeleton to the Demir principle and to the importance of reading convention rights in line with internationally accepted standards. And the cases to which they refer, when they do that, do include, of course, cases which refer in terms to the best interests of the child under Article 3 of the UN Convention on the Rights of the Child. And just to be clear on this issue about the UN Convention, because again, this is another point which has been characterised in a particular way in the skeleton from the Secretary of State, which does not reflect our position. We see that in paragraph 4 and then later in the Secretary of State skeleton. The contention that's made is that the UN Convention adds no value and is an unincorporated international treaty. So may I just be clear on this? Firstly, we indicated in our skeleton, and supported by the local authority, that the UN Convention on the Rights of the Child is a key interpretative aid for the European Court of Human Rights in cases involving the rights of children, when the European Court of Human Rights is interpreting and applying convention rights. That's entirely in keeping with the Demir principle, the convention not being interpreted in a vacuum, but being interpreted in harmony with international principles. We see that from the line of authorities including Neulinger in the European Court of Human Rights. And by virtue of Section 2 of the Human Rights Act, the UNCRC thus plays a role in interpretation of convention rights here. It's also clear from a series of domestic decisions about the role of the UNCRC and its use as an interpretative aid in cases involving children, CZH, HH, and we entirely accept that, of course, when an attempt is made to rely on it in the way that the appellant did in the AB case, it's of a different nature, where an attempt is made to rely on the UNCRC in order to persuade the court to adopt an approach which runs contrary to Strasbourg's established case law. That's the context in which we should see paragraph 60, I believe it was, the paragraph to which you took me earlier, my lord. So quite different. We're much more in the territory of ZH, HH, rather than the AB situation. Now, we did make reference in our skeleton to our position being that the best interest principle has become a principle of customary international law. And we made reference to the Sam Hinga case. I may assist you to hear shortly before lunch. We recognise that at this level that is simply not a point which can be decided. We appreciate that you're bound by Supreme Court authority, where Lord Kerr was in the minority on that issue, and he said it had become a principle of customary international law in the first of the benefit cap cases. And it's not a point which we recognise you can or should decide at this level. So we've made reference to it because we reserve our position. It may be a point that we wish to take if this case were to go further, if I can put it that way. But it's not a point that we ask you to decide. We're relying on the UN Convention on the Rights of the Child as a matter of domestic law, because the UN Convention on the Rights of the Child is a key interpretive aid when you're looking at Article 3 of the European Convention. That's clear from the Strasbourg case law regarding children, and it's clear from the domestic case law regarding children. And that phrase that's used by the majority in the Reese case, and by Lord Wilson, Lady Hale and Lord Clark, about there being universal condemnation in the international community of human trafficking. And we say that when you're dealing with the best interests of the child principle and the condemnation of child abuse, we're in similar territory. Indeed, there's an even stronger background when dealing with the UN Convention on the Rights of the Child in circumstances where it's the most widely ratified human rights treaty in history. And we rely on that not as a non-incorporated treaty, but as a principle of domestic law which should be applied. I don't have very long to go, mindful that you said 3 o'clock, and we have liaised beforehand, so I'm confident that we'll be able to complete it with some liaison over lunchtime within the hour after lunch. I realise it means I haven't taken you to very many authorities just for speed and given you references rather than turning them up. But afterwards I'll have a short bit to go, including taking you to some authorities briefly.
And then you'll hand over to
And
Ms.
then I'll hand over to Miss Markham.
Very good. Well, we'll resume at 2 o'clock.